Start straight off. It's my pleasure to introduce and welcome David Lefkowitz here. He's going to educate us about why Hart was right after all.
Great, thank you. Well, first let me start by saying thank you to Nicole for the invitation to speak today. Thank you to Terry for also helping to make it possible for me to come visit with you here at NUS, and thank you to all of you for taking the time in your schedule to come and talk about Hart on international law. What I'm going to do is walk you through the paper. I was saying to Nicole earlier, I'm terrible when it comes to PowerPoint slides. I can't resist packing way too many words on each slide. But this time around, I actually have a legitimate excuse. I'm going to give you a lot of text, since that's really what we'll be arguing about today. Hart makes very few friends from his final chapter, Concept of Law, the one chapter in which he addresses international law. And it's actually kind of a curious fact, because if you read the chapter carefully, he would seem to be saying things that a lot of people would find attractive. For example, the first part of the chapter he devotes to rebutting the command theory of law as it manifests itself in international law. And you would think that kind of argument would actually find a lot of friends. Of course, not all friends, but a lot of friends. And yet, whenever anybody talks about Hart on international law, they tend to do so in a pretty derogatory fashion. And the question is why? And I think the answer is really comes down to one word, and that word is primitive. So Hart, you can see from this quotation here, which is from the introduction to chapter 10, Hart seems to identify international law with what he had earlier in Concept of Law referred to as a primitive society. And in particular, he contrasts that kind of society with an advanced society, but what he has in mind, and he's explicit about this, is the legal order of a municipal legal order, or a legal order of a moderately well-functioning modern state. Right? And so we have here this claim. Right? We don't have an international legislature, we don't have courts with compulsory jurisdiction, essentially organized sanctions. So the rules for states resemble that simple but primitive form of social structure. And I think this is really the source of a lot of the antagonism to Hart. Oop, I'm going backwards. And I give you here just a couple of examples of remarks that people have made about Hart's treatment of international law. So we have Jeremy Waldron. This essay, this quote comes from an essay that's actually in the book that I just had that picture of. This is actually some of the nicer things that Waldron has to say about Hart on international law. He really gets his Oxford Union style on when it comes to his discussion of Hart on international law. Also, Mehrdad Payanda, in an article that was published in the European Journal of International Law a few years ago, raises many of the same kinds of objections that Waldron raises. Payanda's article actually precedes Waldron's book chapter in about a year or two. But I think this remark here, if you had to think about the deepest insult you could possibly give to Hart, it would be to identify him with Austin. And then Jean Desformont, who makes a good deal of use of Hart's work in Concept of Law and in developing his own what he calls formalist account of international law. When it comes time for him to remark on Hart's discussion of international law, you can see he joins Payanda and Waldron in being disappointed, and I couldn't help but include this given where we are today. We'll see whether Nicole gets his part right here or not. What I'm going to argue is that these understandings of Hart rest, in fact, on two misreadings. But I think that Hart's critics here are not to blame that much for their misreadings. Hart was, to put it nicely, far from clear, I think, in elucidating two different distinctions he has in mind when he contrasts primitive and advanced societies. So on the one hand, we have the functional distinction, right, and that is characterized by the absence or presence of secondary rules to court, right? So whether there are any rules of change, for example, or not. The second distinction that Hart has in mind, I'm going to argue, when he contrasts primitive and advanced societies, is a specialization distinction. That has to do with the absence or presence of a division of labor in the performance of governance tasks. Hart is not always clear about which of these distinctions he has in mind. Partly that's because he had totally fallen in love with the idea of a social rule when he was writing Concept of Law, so he put everything in terms of social rules. The second misunderstanding I'm going to argue has to do with Hart's use of the phrase rule of recognition, what exactly he's referring to when he uses that phrase in Concept of Law. In some cases, I think it serves an epistemic function, and that's the rule of recognition is a genuine norm that actors can use, do use to identify the law of a particular society. But in other cases, I think the best way to read Hart's reference to a rule of recognition is that it refers to the practice of holding accountable that makes it the case that the rules R1, R2, etc. are rules of a particular society. So in that case, Hart is making an ontological claim, not a epistemic claim. Oops. Skip. Yeah, okay. So three things that I want to do in this presentation. The first is I want to sustain the two claims about the misunderstandings that I just described to you. So I'm going to try to show you through a careful reading of chapters 5 and 6 of Concept of Law that the specialization distinction is equally central, perhaps even more central, to Hart's understanding of the distinction between an advanced and primitive society than is the functional distinction. Right. And secondly, I'm going to argue that when Hart deploys the idea of a legal system, most of the time what he has in mind actually concerns the ontology of law, ontological claims regarding the phrase rule of recognition rather than the epistemic understanding of the rule of recognition. In light of those arguments, I'm then going to give you a new take, but what I argue is the correct take on Hart on international law. I'm going to do that by way of showing where Payanda and Waldron go wrong. And hopefully, if we have a few minutes, I will also rebut a couple of other criticisms of Hart that are premised on misunderstandings of his take on international law. So, we start in chapter 5 with Hart's first remarks on primitive society. So if you read just this quotation, which is the first point in Concept of Law where Hart introduces the idea of a primitive society, I think we would come away only with the specialization distinction. What's the difference between a primitive society and an advanced society? Well, it's that in a primitive society, there's no specialization in the performance of governance tasks. If there are any social rules present in the society that causally contribute to the social order, then they exist in virtue of all members, or at least most members of the society, adopting the internal point of view, what Hart calls the internal point of view, with respect to those rules. But there's nothing here about secondary rules or primary rules. Good start, I think. But unfortunately, right after that quote, we get this passage from Hart. Hart thinks, well, but if I just stop here, if I referred to this kind of primitive society as one that had only customary rules, people might misunderstand. They might think that, because they think customary rules are old and that they're not, their normativity is very weak. This is Hart's take on normativity. So to avoid that implication, we're going to refer to a primitive society, primitive social structure, as one of primary rules of obligation. But notice that we've now switched from one way of distinguishing primitive and advanced societies, namely in terms of specialization in the performance of governance tasks, to a second way of distinguishing these two kinds of societies. Right. A primitive society here is going to be one that has only primary rules of obligation, in contrasting with an advanced society which has secondary rules, which has also secondary rules of obligation. At this point in reading Concept of Law, if you were a student in Hart's lectures that were collected in Concept of Law, you'd already be familiar with the idea of a primary rule of obligation. Right? This creates duties. And you'd also have some sense of secondary rules, right, in light of Hart's criticisms of the command theory of law. These two ways of distinguishing primitive and advanced societies show up in the ensuing discussion of the defects of a primitive society. So, if we start with the defect of rigidity, or what Hart calls the static nature of a primitive society, this seems to be the defect where the functional role of secondary rules, presence of secondary rules, seems to be most important to Hart. So if you read this passage here, you might be thinking, right, so the problem with a primitive society is that it lacks secondary rules of change. That seems like a functional matter. But again, I think we need to read this in context. So that quote I just had up is followed by this one right here. And I think in light of this second passage here, we can go back and read that first passage in a way that suggests it's really more about the presence or absence of specialization in the performance of governance tasks than it is about the presence or absence of rules to core, right? Not least because we say we've got an extreme case. And notice one that's perhaps never fully realized in any actual community, including primitive communities of the type that Hart has just mentioned. So Hart says this is really more a kind of the limiting case, not really a claim about actual primitive societies, that they'd have literally no rules of change, no rules, for example, whereby someone who has made a promise could be released from that promise. So again, one reason to think that there are two distinctions going on between primitive and net societies, even in the discussion of the defect of rigidity, the earlier reference to primitive community, and the acknowledgement that it would be an extreme case, one perhaps never fully, never realized, that we had a society that had no rules of change. But there's another important contrast here that Hart has introduced in those two passages that I had up here a moment ago, and that's the contrast between changing the general rules and changing the obligations which arise under the rules in particular cases. Changing the general rules, I want to suggest to you, and I think this is what Hart thinks as well, requires at least some kind of embryonic specialization. It requires some kind of legislative process. That legislative process may be judicial lawmaking, it doesn't have to be a legislature. But that's different than rules that involve just changing the obligations that arise under the rules in particular cases. I'm actually going to come back to this when we get to international law. And finally, in that first passage that I had up here about the defects of a primitive society vis-a-vis rigidity, static nature, Hart talks about deliberately adapting the rules to changing circumstances. And this is something I'm happy to talk about afterwards. I won't talk much about it now, but I think we're pointing here to the difference between customary rule change and legislative change. When it comes to the defect of inefficiency, this has to do with adjudication and enforcement. Here, Hart clearly has in mind specialization in the performance of governance tasks. So, what's the problem with a primitive society? There's no agency, especially in power, to ascertain finally and authoritatively the fact of violations. So we're not talking just about secondary rules, we're talking about agents. Likewise, when it comes to enforcement, in a primitive society, these are not administered by a special agency, but are left to individuals affected or the group at large. And finally, the defect of uncertainty. This is Hart's first passage that refers to a rule of recognition. So when doubts arise as to what the rules are, or their precise scope, in a primitive society, there's no procedure for settling this doubt, either by reference to an authoritative text or to an official. Well, clearly reference to an official is going to be evidence of a distinction that rests on the presence or absence of specialization in the performance of governance tasks, in this case, pronouncing on what the rules are. But I think the same is true actually for the idea of an authoritative text. And the reason I think that is, again, because Hart says so. He says, look, the crucial first step from pre-legal to legal, or better, I think, would be from primitive to advanced, is not merely writing down the social rules. It's the acknowledgement of reference to the writing or inscription as authoritative, which means they have an author, some person who specializes, who is recognized as specializing in ascertaining what the rules are. So I think reference to authoritative text also implicitly involves reference to specialization. So, but why is it only a first step, but not a final step? from pre-legal to legal, or in the same pages, Hart talks about the simplest rule of recognition, the one he's just identified as, in embryonic form, the idea of a legal system. And again, we have the germ of the idea of a legal validity. Why are these all the beginnings, but not the complete existence of a legal system? The answer, I think, is this. For Hart, when Hart's talking about legal system here, I'm going to come back to this in just a moment, what he has in mind is a division of labor in the task of sustaining the practice of holding accountable that constitutes the existence of law. Or really, I should say, any normative laws or social rules. I'm not going to worry too much about what distinguishes legal from non-legal conventional normative orders. And again, Hart characterizes that practice of holding accountable in terms of adopting the internal point of view. So about the idea of a legal system, Hart, I think, is there's some ambiguity in his treatment of that idea in concept of law. And there are some cases where the legal system contrasts with a mere set of laws or primary rules of obligation. And when you introduce a rule of recognition here, what you get is some kind of systematicity. For example, you might arrange the rules in some order of superiority. Hart, when he talks about them, actually refers to orders of superiority on the basis of their source. So he refers, and this is with reference to English law, how legislation is superior to custom. In this case, the rule of reference to a rule of recognition is reference to a genuine rule. I would argue, but again, I'm happy to talk about this more, that it's a purportedly epistemically authoritative description of the practice of holding accountable that constitutes the normative order in question. But most important here, it's a genuine rule. I'm not actually sure about this, as I was rereading the paper to prepare for this, but at least in the paper, I claim that in this sense, a legal system and a rule of recognition, it doesn't presuppose any specialization in the performance of governance tasks. So that's one way in which Hart uses the idea of a legal system, but there are passages, I argue, in which legal system refers not to rules but to agents. Here, legal system refers to the absence or presence of a division of labor in the task of sustaining the law by adopting the internal point of view to the rules that constitute it. In this case, talk of a rule of recognition is a misnomer. It's not a rule, it's not a norm. Rather, what we're referring to here is the social fact constituted by officials' practice of holding themselves and one another accountable. And as that suggests, here, legal system has to do with ontology, not with epistemology. So it might be better in those passages if Hart had said, right, that officials engage in a particular practice of holding accountable as a rule, rather than talking about a rule of recognition. So Hart describes this is a passage in chapter 6 that I think causes a lot of trouble, a lot of misinterpretations. Hart describes as individually necessary and jointly sufficient for the existence of a legal system in a given society, on the one hand, general obedience to the law on the part of subjects, and on the other hand, officials' effective acceptance of common rules for identifying, changing, and adjudicating the law. And the question is, why should we think that satisfaction of both conditions is necessary and not merely sufficient for the existence of law? And a lot of people who get upset with Hart's treatment of international law, I think this is one of the things that gets them upset. Why do we have to have both of these satisfied in order for something to count as a legal system, for instance, in order for international law to count as a legal system? And again, the answer, which I mentioned a few minutes ago, is that only when both conditions are satisfied, at least to some considerable degree, do we have specialization in sustaining the practice of holding accountable that constitutes law. Right? In this passage, when Hart refers to a legal system, a society having a legal system. This is what he means. And I think that was a very long quote from Hart. So long, in fact, that I had to divide it up over 2 slides. Again, Hart's got this love of social rules going in concept of law. Everything has to be in terms of social rules, but in this case, I think it's a distraction. So I wanted to highlight 2 things for you in this passage. The first is, I'm eliminating all these phrases that refer to primary and secondary rules. And I think if you read the passage with those struck out, then the fact that he's talking about this division of labor, right, in sustaining law comes out more clearly. The other thing I want to highlight, because we'll come back to it, is Hart contrasting a legal system characterized this way with what he calls a pre-legal form of social structure. So the first passage here, again, just highlights the 2 individually necessary and jointly sufficient conditions for a legal system. Second passage here says, well, what's it like when you don't have a legal system? Well, what it's like when you don't have a legal system is you don't have specialization in the performance of governance tasks. But the most fruitful way of regarding a legal system, we might say the idea of a legal system, is to observe that the acceptance of the rules as common standards for the group may be split off from the relatively passive matter of the ordinary individual acquiescing in the rules by obeying them for his part alone. And then importantly, we get the idea of legal validity connected to officials. Officials' adherence to a rule of recognition in what Hart is referring to here as a legal system. I should note the last sentence in this very long paragraph that I'm quoting here. Hart says explicitly, I'm not saying this is a good thing, right, if you have a society like this. It might well be a terrible thing. But I'm just trying to develop a clear analysis of a certain concept, which is the concept of a legal system. Not the only thing the phrase a legal system might refer to, but this particular way of understanding this, as he says, most fruitful way of understanding the idea of a legal system. So to sum up this discussion of the 2 different references of the phrase rule of recognition and the ambiguity in the legal system, when Hart invokes the concept of rule of recognition to serve the epistemic function, what he has in mind is a hierarchy of rules. By the way, he might have been mistaken about that. You could have a rule of recognition that plays an epistemic function in identifying what the rules of the society are without doing any kind of ordering of those rules. But whenever Hart talks about the epistemic function of the rule of recognition, he always talks about doing both these things, right? Ordering and identifying. When the rule of recognition is invoked, right, for ontological purposes, what Hart has in mind is not a hierarchy of rules, but a hierarchy of actors. Officials and subjects, rulers and ruled. Okay, so this is my reading of Hart's discussion in chapters 5 and 6. I now want to discuss his take on international law in light of my reading of chapters 5 and 6. This is a painstakingly long passage from Payende's paper. Waldron endorses it. The key point here is that both Waldron and Payende read Hart in chapter 10 as saying international law consists solely of primary rules of obligation, no secondary rules. And all of their criticisms are premised on that understanding of what Hart has to say in chapter 10. What's actually pretty amusing about this is that Hart explicitly acknowledges secondary rules. So he explicitly acknowledges the Permanent Court of International Justice, subsequently replaced with the ICJ. He explicitly acknowledges treaty, right? The fact that international law can be created through treaties. So clearly he recognizes that international law, even when he was writing in the 50s, had secondary rules. So it can't really be that he thinks international law consists only of primary rules. And yet despite that, and Waldron is explicit about acknowledging that, both of the critics here still read Hart as arguing that international law contains only primary rules of obligation. What they're doing is they're assuming that Hart's relying on the functional distinction that he has in mind when he distinguishes primitive from advanced societies. But in fact, I want to argue what Hart has in mind is the specialization distinction. So why? Why think that I've got it right, Waldron kind of had it wrong? Well, the first reason is that Hart tells us that's what he has in mind. And so in the introductory section it says, right, and this goes back to that quote I had up at the first slide, it's indeed arguable, as we shall show, that international law not only lacks the secondary rules of change and adjudication which provide for legislatures and courts. Right at the beginning of the chapter he says, I'm not telling you it doesn't have any secondary rules, I'm just telling you it doesn't have these kind of secondary rules. Namely, the kinds that distinguish an advanced society with specialization in the performance of governance tasks from a primitive society understood as one that lacks that specialization. Earlier when I was talking, giving you a reading of Hart on the defect of rigidity, or quality being static, Hart distinguished then between two kinds of rigidity that might plague a primitive society. One is no way of making deliberate changes to general rules. The second is no way of making changes to obligations that arise under the rules in particular cases. My suggestion is that Hart, you could argue about whether he's right about this, but Hart understands secondary rules that constitute treaty making as examples of the latter. Which is just to say, international law, at least in the 50s, is not a primitive society in the sense of having no secondary rules that make it possible for example, countries to acquire obligations vis-a-vis their treaty partners. But what it doesn't have, and Hart says this passage right at the end of this chapter, he says it doesn't have any way of making deliberate changes that are binding on all members of the society in question, international society in this case. Let's suppose, for simplicity's sake, that's the Society of States. And Waldron notes this passage in which Hart says, if international law were to evolve so that multilateral treaties were generally recognized as binding on all states, not just the parties to the treaty, well then it would no longer be a primitive society. And Waldron just scratches his head and says, I don't know why Hart wrote this, I don't know what he's thinking. So I think now we do. We see it's the specialization distinction that Hart has in mind. Again, when it comes to enforcement and adjudication, Hart does acknowledge that international law has some secondary rules, specify or at least limiting the penalties for a violation. But he's just skeptical about how much these will contribute to the production of social order, because members of international society rely almost exclusively on self-help. So, presence of those secondary rules vis-a-vis enforcement is maybe one step away from the probably just limiting case, never actually realized case, and having no secondary rules specifying permissible enforcement. But it's not a very large step. Likewise for adjudication. It's probably clear to many people in the room, this is a place where international law has advanced most since Hart wrote Concept of Law. But again, keep in mind here that Hart is making an empirical claim about the state of international law at the time that he's writing. He's not making a conceptual claim that says international law would have to always be this way. Nevertheless, when you lack courts with compulsory jurisdiction, the ability of those courts to contribute to the production of social order is going to be reduced. Right up there with calling international law primitive, I think this quote from the very end of chapter 10 is one that gets under a lot of people's skins. My guess is, Nicole probably said she wouldn't remember why, but this might be the explanation for that quote I had up from Nicole earlier. She said, contrary to Hart, there are secondary rules, including rules of recognition. Well, here's Hart saying there's no basic rule of recognition. Basic rule because he's been talking about Kelsing, so he switched into that language instead of rule of recognition. So, remember I said that there are two ways to understand reference to rule of recognition. If we understand it in the epistemic sense, or playing the epistemic function, then it's clearly false, and it was false at the time that Hart wrote it in the 1950s. So I have in mind here something like Article 38 of the ICJ statute, which identifies sources of international law, and some would argue identifies a hierarchy of norms. The claim regarding the absence of any systematicity is, I'm going to say, overstated, even with all the worries about fragmentation of international law. But what if we understand that quote I just had up here, that quote from Hart, in ontological terms instead of epistemic terms? Well, a reminder, a legal system, when we're talking about ontology, has a composite character. If we're talking about an advanced society, one that has a legal system. And I don't think there are too many international legal theorists that would disagree with Hart's claim. In fact, neither Waldron nor Priande does. The only people who would disagree with this are those who mistakenly think that international law's status as law depends on its being a system, a legal system in this sense, in the sense of possessing this kind of specialization. That's the people that Hart is targeting in the last section of Chapter 10. And in fact, what I say in the paper, Marty Koskanemi has a fair claim to being an authority on the history of international law. Says in a paper, there's this long history of international legal theorists, international lawyers, feeling the need to show that international law has all of those forms of specialization that municipal law has. And that's exactly the people that Hart wants to target, those who think in order to be law, international law has to have that specialization. So, this is how I would rephrase that quote that causes so much trouble at the end of Chapter 10. Hart, by the way, explicitly states, we could formulate a rule of recognition for international and ontological rule. It's the one that Kelsen suggests, right? States should behave as they have customarily behaved. Hart says, yes, so that's fine. That's a rule, but it just doesn't tell us anything interesting. Only once we get specialization does a rule of recognition tell us something interesting ontologically about the existence conditions for law. Okay. Am I doing on time? Do I have a few minutes?
2 minutes. Or
Okay.
actually, no, we started slightly late, so up to 5.
All right. I can do it. All right, so again, 2 things I've done so far. I gave you a reading of chapters 5 and 6, in which I tried to argue that there's actually 2 distinctions going on between a primitive and an advanced society. I then used my interpretation of those passages in chapters 5 and 6 to offer what I claim is a superior reading of chapter 10, Hart's chapter on international law, superior to Priande and Waldron's in particular. And now I just want to draw on that to rebut a few other criticisms of Hart's take on international law. So Waldron actually ever so briefly, considers exactly this reading of Hart on international law that I've defended here. And he says, well, but it can't be that. That can't be what Hart had in mind, because that's just so trivial. So, but here's a few reasons to think it's not trivial. Or also reasons to think that trivial doesn't mean unimportant. Or something we shouldn't, it's not nevertheless important to note, especially if what you're writing is a book that's intended for undergraduates getting their first taste of philosophy of law. So it's not trivial if the people we're targeting are people who think that specialization in governance tasks is a necessary condition for international law to be law. It's also not trivial if what we're interested in doing is providing an account of how law contributes to the production of social order. And that, I think, is actually the best reading of not everything that goes on in concept of law, but certainly a lot of what goes on in concept of law. That is the social scientific take that takes very seriously the passage in the introduction where Hart refers to his project as a project in descriptive sociology. I think it's plausible to think that how well a normative order will contribute to the production of social order, how well a system of norms will contribute to the production of social order, does depend to a significant degree on the extent of specialization. And finally, we might point out that the observation that municipal law includes power conferring rules is similarly trivial, in the sense that as soon as somebody points it out to you, you say, well, of course. Right? Any of us who have taught this to our students, taught the first couple chapters of concept of law, right? They fall in love with the command theory, or especially if you just ask them, so what do you think makes law? They'll give you command theory in about 30 seconds. And then you start pointing out all the power rules that exist. And they say, oh yeah, of course law involves all those power rules. But you lose sight of that. This was Hart's point. You can lose sight of that when you're under the influence of a bad legal theory. Well, I think Hart had the same idea when it came to international law. People were under the influence of a bad legal theory, either the command theory, or the thought that it was a necessary condition for the existence of law or a legal system that you have specialization in the performance of governance tasks. And he's just trying to clear obstacles to good theorizing about law, or international law in this case. This from the title of Waldron's paper, where he criticizes Hart. So, the title of Waldron's paper is A Relatively Small and Unimportant Part of Jurisprudence, but without the question mark. Hart on international law. Here, it's catchy, I'll give him that, but Waldron is playing fast and loose with the actual text. So here's the actual passage. And Hart, I think, is just talking about the use of the expressions. He's just talking about how people have talked. But as he reiterates numerous times in concept of law, he's not interested in talk, documenting how people talk. He's not interested in definitions. His interest is in facilitating productive theoretical inquiry and sound moral deliberation. So I think if we read the passage, say carefully to be generous to Chairman Waldron, then I think we can see there's no reason to assume that this passage implies that Hart thought international law was a small and unimportant part of jurisprudence. In fact, Chapter 10 is important for three reasons. I think it's an important contribution to the jurisprudential aims of concept of law. It does three things. First, reinforces the case against the command theory of law. The second, it reinforces distinctions that Hart has drawn in, I want to say chapters 7 and 8, between law and morality, and in particular, the thesis that legal validity does not depend on law's merits. And then, I've gone on about this enough, specialization. This just having some fun at the expense of people some of us may know. But this actually is pretty common amongst people who I think are quite good at jurisprudence. So Hart characterizes a primitive society as pre-legal, characterizes international law as a primitive society, so right, it follows that for Hart, international law is not law, it's only pre-legal. Brian Tamanaha makes this claim, Arthur Cutterell makes this claim, right? And then they infer from that this is evidence of a general claim that they level against Hart, which is that he gives unwarranted priority to municipal law in his analysis of the concept of law. But I think, hopefully, at this point in the talk, you see why these objections. Right? The first objection just rests on a misunderstanding of Hart, and if that's so, then the second objection also fails. So, Hart actually was pretty common for him, sets himself a very modest goal in Chapter 10. He's just, again, trying to clear the landscape of any kind of confusions that might get in the way of practical or theoretical insights into law. But I want to suggest that a bolder claim is actually warranted. That by foregrounding the resemblance international law bears to a simple social order, we get both theoretical and practical and moral benefits. So, the theoretical benefits. We get a better understanding of how international law produces social order, including the limits of its ability to do so. And I have in mind here now, at this point, 30 plus years of work at the intersection, in particular of international relations theory and international law about international law's effectiveness. Even if you have some doubts about some of the claims that might be made, as for example Terry does that work. I don't think we can call into question the many insights about how law does contribute to the production of social order that we've gained from that interdisciplinary dialogue. And then two practical moral benefits. One is international law is going to be a pretty limited tool, I think, for achieving a wide range of justice goals. And so theorists ought to think broadly about the various means that they might adopt to try to advance justice. Secondly, when they do want to make claims about international law as a means or maybe constitutive of global justice, their theorizing should start from a well-informed understanding of how the international legal order actually functions, which means starting with an appreciation for the fact that it lacks a legislature, it lacks compulsory courts, and it lacks centralized enforcement. So thank you.